and to people on the East Coast coming back from lunch. We've got David Kaminsky and Christine Riley here today to talk about mobile communications marketing and compliance strategies to tackle the onslaught of the TCPA. And we've got a full presentation with lots of great information, so we want to kind of jump right into it. Apologize for getting a little slow start, but we've got 3 speakers, so we want to make sure we're dialed in. And you got questions throughout, feel free to use GoToMeeting to submit those to us. There's an option there for chat, and we'll try to get some time towards the end to go through those questions. And both David and Christine bring tremendous experience, and they're out there in the field fighting a good fight. So I want to get to it and give them a chance to introduce themselves. Maybe Christine,
Thank
you
you,
want to say
Ryan.
hello to?
Yes, I'm blaming our delay this morning on the rain here in California, which is very needed, but a very wet morning here in California. Good morning to those on the West Coast, and good afternoon to those on the East Coast. I am particularly thrilled to be here today to partner up once again with Contact Center Compliance and with my friend and colleague, David Kaminsky, to do another TCPA webinar. So welcome, everyone. So let's get started today. We have a full deck here to talk about mobile marketing and the TCPA. And I think David and I could probably talk about this topic for at least several hours. But don't worry, today is just an hour and a half. And we hope to be able to take questions at the end.
So this is Ryan Thurman, and I just wanted to kind of tell people a little bit about our company. We're kind of sponsoring putting on the webinar today as part of our kind of webinar series that we do. We try to bring leading experts out that can really break things down in terms of what's going on and what types of technology people are using. So we work with a lot of mutual clients with both David and Christine, and we help people really stay focused on having a good compliance track record, making sure that they have proof positive that they've done an accurate job at either do not call compliance or TCPA compliance, including VoIP scrubbing, litigator type scrubbing on top of the mobile identification that we do. So we can talk to people offline a little bit more about our expertise, and we offer usually for people that come to our webinars a way to do a free test with us, kind of verify their contact data is compliant so they don't get caught by any surprises, because there's some substantial penalties out there, as everybody's aware. So we'll definitely have that available. So appreciate being able to participate and bring together some information here. So we'll hand it back off to the other speakers, and we'll get into the meat of this presentation.
Great. Well, let's get started.
Great. Hello, everyone. I'm David Kaminsky, and there's our bios, which you can read at your leisure at another time. Ryan's going to provide this PowerPoint to you at a different time. So
yeah, you'll be able to get the slides. I know questions are going to come up. You'll be able to get the slides via link from us right after the presentation, and we're also recording today's presentation. So if you have to jump out early, or you have a colleague that couldn't attend, we'll also provide the information so you can stream the content later.
Well, everybody, you know the TCPA. It's a problematic statute, and yes, this is a little joke that we've added in there, and it fit very perfectly. But we're going to try to take you through it, and we're going to try to show you how that, if you do the right thing, and if you comply with the rules in a way we're going to discuss, we can help at least minimize or mitigate the risks of potential liability in this insane statute. We're going to also talk about, Christine and I will be the changes in the landscape here that we hope are coming through the FCC, through the multitude of petitions that have been filed on dialer issues, reassigned numbers, and we'll get into that. So with that, let's move it forward, Ryan.
All right. Well, let's talk about what the TCPA means. You might have heard before that the TCPA stands for Telephone Consumer Protection Act. So what it actually really stands for is tread carefully, piranhas ahead. And I think what David is really referencing is that we have seen what can only be described as a feeding frenzy of litigation over the last several years. And we're not really seeing any decline in that amount of litigation. We're only really seeing a steady, either a pretty consistent amount of litigation, if not even more litigation, as a lot of petitions have been filed and really haven't gotten a resolution on a lot of really key issues in this space. When we figure out why is it that we have so much of this litigation, why is the TCPA so incredibly popular? Well, when it comes to mobile marketing, of course, it's really about how we've become such a huge mobile society. All of us know that pretty much everyone has a cell phone these days. Even young children have a cell phone. And there are so many mobile phones in the world, and we are all just strapped to our mobile devices. Here are just a few statistics on this slide, just giving you an idea of just how big our mobile society has become. One of the more interesting statistics, which we're going to get into a little bit later, is text messaging. You know, back in 1991, when the TCPA was enacted, there were not text messages. No one ever heard of a text message. That didn't come until several years later, maybe even a decade later. But these days, most phones have text messaging capability. And a staggering statistic is that 95 to 98% of text messages are opened within minutes of receipt. It's a pretty staggering statistic. As a result, businesses are really trying to communicate with consumers by mobile phones because it is a primary means of contact for a lot of consumers, some of whom don't even have residential lines anymore, and it is incredibly effective in reaching a target audience. On the next few slides here, there are some really interesting statistics on mobile devices. And I won't really get too much into them, but they're really kind of interesting in looking at sort of the divide between different devices by household through generations, and also looking at the types of businesses and who signs up for text messaging. So Ryan, if you could advance the slides to number 7, today's mobile society. Won't spend a lot of time on this, but this is really worth looking at after today's presentation. Just getting an idea of the gaps between gender and age and who is signing up for text messaging is really interesting. And I think you'll find some bit of a surprise here. You know, for example, looking at the gender differences, who doesn't sign up for text messages? Well, believe it or not, it is more women who are not inclined to sign up for text messaging as much as men, which I found to be a bit surprising. But in any case, definitely worth taking a look at these if you're interested in knowing some more statistics on today's mobile society. Advancing to the next slide. What does the TCPA mean and what does it cover? I think most of you are pretty sophisticated and you've probably heard a ton about the TCPA, so I won't spend too much time going over this. But for those of you that are new to the TCPA, there are just a few things you need to understand about the statute. It's a federal statute enacted in 1991, and essentially regulates and restricts the use of different technology to initiate outbound telephone calls. When we talk about technology under the TCPA, we are speaking about artificial voices, pre-recorded voice messages, and autodialers, or the term under the statute is automatic telephone dialing system, which David is going to talk to you about very shortly. There are also other rules under the TCPA, including the do not call rules. There is a national registry of do not call numbers, and there are also state do not call lists and also regulations on that. And that's almost its own separate section, which we will talk about briefly today as well. The regulatory authority in charge of the TCPA is the Federal Communications Commission. Next slide. Another reason why the TCPA is so incredibly popular is it really incentivizes plaintiffs and professional plaintiffs and their class action attorneys to file these lawsuits. And it's easy to see when you look at this slide. There are statutory damages under the TCPA, and they are $500 per call or actual damages, and up to $1,500 per call if the violation is considered willful or knowing. I think you can pretty much take away actual damages from this calculation because there are virtually no real actual damages under the statute. So inevitably, you're looking at a $500 minimum for a call or a text message. And I won't really get into the numbers, but you can see that if you're doing a large campaign for mobile marketing and there is a possible TCPA issue, the numbers can be staggering. And that is why compliance is so critically important in this area.
Christine, that's a great point. You know, I was involved in a TCPA litigation, one of many, in one particular case with a very small company. And we told the judge, she goes, well, what's your outside liability in this case? Explain it. I said, well, based upon the number of calls made over, let's say, just a one-year period, times, let's just say, the $1,500 willful damages per call statutory fee, we're looking at approximately $4 billion. And the judge just, her mouth literally dropped, and I said, yes, that amount exceeds the U.S. government's bailout of Chrysler Corporation. That's the insanity of the statute. And it started to sink in, and when you frame it in that way, judges get how ridiculous and absurd the statute is.
Absolutely. And I think as a result of those kind of, catastrophic numbers, really just crazy numbers, what really tends to happen in these types of cases is you're able to get rid of them on the merits because you have strong case for defense, or a lot of these cases end up settling, and they settle in millions of dollars very often, unless the company does not have the financial ability to pay that kind of settlement. So that's what the reality of the statute is. It usually results in a lot of large settlements unless you're able to have a strong defense and get rid of the case early on.
That's right, Christine. Great point. You know, unfortunately, that sometimes the TCPA, because of the way it's framed and the limited defenses, these are bet the farm cases. And if your only fight is to fight class certification at that stage, and you have a 50-50 shot to win or lose, it's a huge gamble. And most of these companies, we have seen, and we could give you slides also on just the statistics on class action settlements. It's overwhelming, and these companies realize that they have to settle rather than fight, because the fight is again, a bet the farm issue.
Well, let's talk really briefly about what the TCPA covers before I hand it over to David to talk about some more of the really tricky, thorny issues that really make it difficult to have a strong defense in this area. This is really important, and we talk about this in every single TCPA presentation, but I feel like sometimes we get lost in what the TCPA covers. It does not cover all mobile calls necessarily, okay? And it doesn't necessarily cover all residential calls. It's really important to realize when you start an analysis of a TCPA case, number one, is the TCPA implicated in this case? And this is how you find out if it is. When we talk about residential lines, we're talking about calls that are initiated using an artificial voice or pre-recorded voice message. What that means is that if you are initiating calls to residential lines using a live operator or even an autodialer, you are not even triggering the TCPA.
So, Christine, are you saying that I can use my whatever is an autodialer, but I can use my dialing equipment all day to call, let's say, landlines, and I may not have any prospective or potential liability if I'm not leaving those messages?
You can autodial a residential line all day long if you like and not have a TCPA issue. That, of course, you still have to worry about your do not call provisions. There's a note here at the bottom. Do not call requirements apply to both mobile and residential lines. And it doesn't matter how you're calling, whether you're calling with an artificial voice, a pre-recorded voice message, or an autodialer. Do not call means exactly that. Do not call. For our mobile phones, it covers calls that are initiated using the artificial voice or pre-recorded voice message. But, and here's the tricky part, the automatic telephone dialing system. And this is really sort of the heart of where we get into a lot of tricky, thorny issues when it comes to mobile marketing. Are you using an autodialer? And I'm going to hand it over to David to really give you an overview of what it means to be using an automatic telephone dialing system.
And I know so many of you are saying, my God, what the hell is an autodialer? And, you know, it's all over the board throughout the country. And there's, you know, at least 40 FCC petitions that are trying to get clarity from the FCC as to what is an automatic telephone dialing system. And I know the FCC is struggling with this for reasons we'll discuss. Basically, so the statutory definition, which you're looking at right here, from the TCPA itself says, look, it's equipment. It's got the capacity to store or produce numbers to be called using a random and sequential number generator. The key word there is equipment that has the capacity. And that's the problem with this statute because of the word capacity, the ability to. That's why courts are saying, many courts are saying, we don't care how you're using your dialing equipment at the given moment. What does it have the capacity to do? So it's the ability to store or produce numbers using a random and sequential number generator. Well, as many of you know, most of your dialers today, they don't have these random or sequential number generator programs. Please, everyone on the phone, call your IT people immediately after we're finished with this session and ask them to make sure that whatever dialing system or dialing equipment you're using, there are no random or sequential number generator programs in your system. And another thing to just think about is something called legacy software. In one case that I'm litigating class action, we noticed that after we went into the system and dug deep, there was some old something called legacy software that actually had random and sequential number generator capability that no one knew about and no one could have known about. So that's something to think about. Next. Again, so we go to, let's go one back. We're going to talk about the FCC because the FCC now interplays with the TCPA. The FCC said, you know, we've seen this definition in a statute and it's all lovely, but sorry, that's old school. And what we're talking about is, look, if your system has the capacity to dial numbers without human intervention, forgetting about that statute, then you have potentially a dialer under the TCPA in our view. Basically, and what the FCC did is they looked at a predictive dialer and they said, hey, these predictive dialers, look, they can route a number to a person, but that's not really what we're concerned about. It's not so much the predictive capability, it's the fact that that system that you're using, these predictive dialers, we know have auto dial capability and we don't like them, and we deem all of these predictive dialers to be auto dialers under the TCPA, and that is the subject of course huge fights and 40 petitions before the FCC on that very issue. Some of the petitions are saying this, hey, what is capacity under the statute? What does that mean? And you've got to rule that that means present capacity. They also say, forget about the FCC statute. Please, FCC, go back to the statute itself and let us just deal with the statutory definition because at least we have a fight there. And then some petitions are saying, if you're going to say what you're going to say, FCC, about this capacity to dial without human intervention, also require that our dialer must also meet the statutory definition, meaning that not only does it have the capacity to dial without human intervention, but that it also is equipment that can store or produce numbers to be called using that random or sequential number generator. It's anyone's guess what the FCC does, but they're in a struggle right now because they're concerned about opening up the floodgates to everyone and everybody with regard to dialers if they change their laws right now. Next. So we've got several cases, and the three cases that really follow, we've got the Dominguez case, a case called Sherman, and then a case called Marks. Basically, these cases are dealing with text message calls, and the courts here are analyzing whether the defendant at issue was using a automatic telephone dialing system under the TCPA. So in Dominguez versus Yahoo, great decision out of Pennsylvania. Pennsylvania hates the TCPA. Look at all of their decisions. They are so defense-friendly. Sometimes they're over the top and are never going to stick, but hey, we got to take it where we can get it, and these are great decisions for us. And the Dominguez said basically, this is it. The statute says what it says. It means what it says. It's clear and unambiguous, and guess what? It says random and sequential number generation. So that's what we're going to rely on, and we're not going to look at the broader interpretation of the FCC because we can't. When a statute's clear and unambiguous, that's the end of the story. You look at what the FCC definition says, and that's it. Next. Great decision. But then we come into California, and we come into the Sherman decision. And the Sherman decision, interestingly, is from California, which is governed by the Ninth Circuit. The Ninth Circuit has the Satterfield decision, which you all know about, the Satterfield Ninth Circuit decision back from 2009. And that said, hey, guess what, Ninth Circuit and all the states that are bound by this interpretation, we say that the statute is clear and unambiguous. The statute says what it says about a dialer. It's got its own definition. Congress defined it, and we think it's clear. So guess what? You don't look at the FCC, the regulatory body that is relegated to interpret the TCPA, because there is no need to do so. You stop there. So that's what Sherman versus Yahoo said, okay, I'm going to go with that, and I'm going to look at just the statutory definition, even though I know this FCC has their own definition, but I'm going to say, you know what the focus needs to be on? Focus needs to be on whether the equipment has the capacity to store numbers to be called and can randomly and sequentially dial numbers. So they say store and dial random and sequential numbers. Well, that's not what the statute says, but this is how broadly this judge has interpreted. Next. I mean, this is craziness, right? And this is from a court within the Ninth Circuit that said you only should look at the statutory definition. But then we get to a great recent decision, which you all should read. It's called Marks versus Crunch. And this judge made some terrific rulings and basically held that look. We're looking at a text message platform here. It did not contain a random or sequential number generator. And this judge said, I think I'm stuck with that ruling. I think I'm stuck with the TCPA's definition because the Ninth Circuit in Satterfield said that I have to be. But she made also a fantastic point. She says, look, I get it that the FCC has purview over this TCPA. And I get that they can, define things, they can clarify things, but guess what? They only have purview over what is called the 227B section of the TCPA, the definition section of what is a violation. That's the 227B where it talks about you are prohibited from calling using an automatic telephone dialing system. But in 227A, that's where the FCC, that's where Congress has its definitions. They never gave the FCC authority to touch the definition sections. So FCC, this judge said, you have no right to touch or define what is a dialer different than what Congress has defined it already. So I'm going to ignore what you did. You had no right to do it. It's a fantastic decision. She makes great sense. But it's funny. This judge here, she is sitting in Marks right next door, and I mean literally next door to the judge in the same courthouse in the Sherman case. She came up with a terrific argument, a way that the judge in Sherman never looked at. So this is the way, I think, to argue the dialer defense because this judge laid it out so beautifully. Very terrific case.
It really is a fantastic decision, and we're really hoping we see more of this, particularly in California where the case law hasn't been necessarily very friendly to the defense side. But I have a question for you, David. With the law the way it is right now, the FCC having, its broadened expansion of what autodialer means, and courts being all over the place, if you have a company that is sending out text messages en masse, Yeah, do they necessarily have an autodialer issue?
That's a good question. So, Christine, sort of let me parse this a couple different ways. So in one case where the defense was trying to argue that it didn't have an autodialer, and the plaintiff actually had an expert in the case and the plaintiff had not yet fully examined the dialer itself to break it down and said why it does or does not constitute a dialer in his opinion under the statute. What that expert said is, looking at their system, within about a month, they sent out over 2 million text messages. He said there was no possible way to do that unless there was a lack of human intervention with regard to the sending of the text messages. You couldn't have human intervention, so they couldn't have, quote, if you're following the FCC ruling, they probably had a dialer because there was no way they didn't have human intervention to get all those texts out. By virtue of the fact that you're just using a dialing system and you're sending out text messages, do you violate the TCPA? It's a tough call. It depends sometimes where you are, in what jurisdiction, and how the court looks at it. Are they going to stick only with the TCPA dialer definition? Or are they going to look at the TCPA and the FCC as a combo, or just the FCC definition? Again, Christine, you've said this before. If they stick just with the TCPA definition as they did with Marks, and that's the way to argue it, then you have a good shot at this. But unfortunately, even the courts in California, as Christine just said, where we had this Ninth Circuit great Satterfield decision which says you only stick to the statutory definition, you would not believe how broadly that is being interpreted by hundreds of courts within California and then courts outside of California. And then, of course, in the East Coast, the FCC, some of the courts are saying, hey, the Satterfield decision, it sounds great and I may follow it, but other courts are saying, hey, I'm not bound by it. I'm not within the Ninth Circuit, so I don't have to follow Satterfield. And, yeah, what they said sort of makes sense, but I don't agree with it. So that's the problem here, Christine.
I think that's exactly right. I mean, I think the bottom line is when we talk about the autodialer issue, it is a particularly difficult issue. When you're looking at trying to get rid of these kinds of cases on the pleading stage, for example, it is very difficult to get rid of a case saying that they didn't adequately allege or plead an autodialer definition. Most courts are finding that tracking the language of the statute is enough. So very difficult at the motion to dismiss or pleading stage. And then when we get to the summary judgment stage where you have the opportunity to present evidence, it is also a very difficult position to be in because then it often becomes a battle of the experts. What does your system do? What kind of latent capabilities does it have? What kind of capacities can be done? And very often, like you saw in the Satterfield case in the Ninth Circuit, very often you're going to have one expert that's saying, no, it's not an autodialer. And you're going to have the plaintiff expert that's saying, no, it really is an autodialer. And where that leaves the courts very often is it's a factual issue that cannot be determined on summary judgment. So, what I advise my clients is, yes, let's see if we can have an autodialer defense. And it's certainly an area to look into. And particularly if your system has some kind of human intervention that you can work with, or it doesn't have present capacity, it is definitely something to bolster up. But very often I say, do we have consent to make the call? That is a cleaner and easier way often to get rid of these cases if you have it. So let's advance to slide 18 and talk about consent. And this really is a critical primary issue in these types of cases. What kind of consent do you need to make telephone calls with, let's say, an autodialer or artificial voices or pre-recorded voice messages to mobile phones? Well, bottom line is, you need some kind of consent. If you're using that type of automated dialing equipment or artificial voices or the pre-recorded voice messages, always need some kind of consent. And the consent is going to change depending on the type of call that you make. If you are making what would be termed a customer service call, an informational call, you need prior express consent. It could be verbal, It could be written. An example of a customer service call is, let's say you get a call from your bank. Were you satisfied with the service you received today? That is customer service. It's not telemarketing. It's not marketing. It is really informational. Now, I know it says you can have verbal or you can have written consent, but I'm going to tell you this. When you get into one of these cases, you really want to have written consent as much as possible. And you might be asking, well, why? It says I can have verbal or written consent. Because when someone challenges you and says, you did not have consent to call me, you then have the burden of showing that you did, in fact, have that consent. And by far, the most compelling evidence is something in writing, something that you can show saying, no, you consented to this call. You either went on a web page, you clicked certain buttons, you signed your name on a written form, and it could be handwritten, it could be electronic, but you want to have something tangible so that you can go back to the plaintiff. You can go back to counsel and say, you're wrong. You have no case, and you need to dismiss it. That is compelling evidence.
That's a great point, Christine. And look, when you're dealing with class actions, if you can knock out the lead plaintiff from the get-go because you have consent and you can demonstrate it, that's the end of the story if you're in the early stages of the case and there is no class certification ruling by the court. So if you are pre-certification and you've got consent and the lead plaintiff gave consent and you can unequivocally demonstrate it, then you want to file your motion, you want to file your evidence, or hand it to the plaintiff and say, this is what we're going to do. We're going to file this motion. You're out of the door, because if the lead plaintiff doesn't have consent, she can't represent a class of persons who don't have consent, because she's not typical or common with everybody else, and the class fails, and that's great. Also, what Christine was saying, when you're looking at this from a class action standpoint, how difficult is it to try to get the evidence to demonstrate, oh, okay, the lead plaintiff didn't give consent, but I've got consent for the entire class, and half of them gave it to me orally, half of them gave it to me this way. How are you ever going to demonstrate that unequivocally? It's going to be a fight and a battle from here to the end of time. But if you have that in writing, and if you're able to say, which I know is difficult, trust me, all of the consents that we get and everything we have is in writing, and here it is. We can just produce, 1,000 records, 200,000 records, 300,000. What do you want, plaintiff? If that's your protocol, then you have a good way to try to defeat these classes.
Absolutely, and I really can't stress that enough. We'll talk a little bit later in this presentation about how you get that proper consent and how you document it. And that really should be a focus point. Understanding that it's not always possible to get that kind of consent and have it in writing, but to the extent that you can, and you can have policies and procedures in doing this, it will really help you fend off any potential litigation that you have.
So, Christine, real quick, we've got this picture in the corner, which I don't know exactly where that came from, but we have a woman there, it appears, who is handing her husband, let's say, a pot of soup, and obviously he doesn't like her cooking, so he proceeds to shoot her with a laser gun. So I guess with that particular picture, doesn't look like consent to me.
It looks like a staple gun.
Okay, so he's going to staple gun his... Yeah, it's just not going well. He's going to staple gun his wife because he doesn't want that darn soup. Clearly not consent in this context. What we're saying is that consent has to be clear and unequivocal.
And just to wrap this up, for your debt collection calls, they are also not telemarketing, so you do need the prior express, written, or oral consent. And let's focus on what today's presentation is, your marketing calls. Well, here's where it gets really interesting. As most of you know, as of October 16th of last year, the FCC came out with some new rules. They're now requiring prior express written consent to make those types of calls using automated technology. A very huge change in mobile marketing. I mean, we've been terming it...
And a huge burden, right, Christine?
Huge burden. We've dubbed it sort of the TCPA wireless cliff. I mean, everyone's like, well, what do we do with this? How do we comply with this? it is a huge undertaking because prior express written consent is very specifically defined, has very specific requirements. And I'm not going to lie to you. They are difficult. And you really have to be very, very up on your compliance in order to make sure you are going to be free of having to deal with these types of claims. So let's get right to it in terms of what are these new written consent requirements. Next slide, prior express written consent. Well, this is my personal checklist that I literally have posted up in my office next to my computer because I get tons of calls about this. Am I doing it right? Is this the right kind of disclosure? Have I gotten everything covered? And I think I've memorized them, but I always like to have my checklist right there so I can make sure, okay, check them off and make sure you have everything. A few really important things here. You need to identify the specific seller to whom consent is being provided. That is not always easy, particularly if you're doing lead generation. What the FCC contemplates is you actually identify the name of a specific seller, meaning an actual company name. Not always easy to do, and we're going to talk about that in a moment. You need to, of course, identify the consumer's phone number. That's at issue that you're getting consent for. You also need to have what is called an affirmative agreement. You need to be having this consumer saying that they agree, they consent to get these calls. And now there are also several disclosure requirements. You are required to disclose that the consumer is authorizing you to engage in advertising or telemarketing. And another way of saying that is maybe offers for goods or services. They also want you to disclose to these consumers that the calls are going to be made using automated technology. Finally, they want you to disclose that the consumer is not required to provide consent as a condition of purchasing goods or services. And a question I get very often is, sometimes that doesn't even make sense in the context in which you're getting consent. So there's a question, do you always need to say that? Which we'll get into in a moment. And lastly, you need to have some kind of written signature from the consumer. So before you get too worried about that, handwritten signatures are great, but that's just not how we work in today's digital world. You can get signatures electronically through the e-Sign Act, and that could be telephone recording, telephone key press, web forms, mobile apps. There really is good news on that front. There are just a variety of ways in which you can get consent electronically, and that leads to some good news here. We will now talk just a moment about what is telemarketing. I always include this in the slide because I do get this question. I get questions from clients who tell me, oh, but I'm not doing telemarketing, Christine. And then we get into a discussion of, okay, tell me exactly what your message is, what you're doing here, how this is all working. And lo and behold, we find out, no, it is telemarketing. What you need to understand, and this is so important, telemarketing is very broadly defined in the regulations. There are two terms, advertisement and telemarketing. Advertisement is even broader, and it says any material advertising the commercial availability or quality of any property, goods, or services. And that's even broader than the telemarketing definition right below it. What I tell my clients is, as a general rule, if your call is not purely informational in its purpose and message, it is probably telemarketing, and you should operate under the assumption that it's telemarketing. And let me just give you an example. There is a well-known case, of course, it's in the Ninth Circuit. It's called the Chesbro versus Best Buy stores. And in that case, Best Buy was sending out, was making calls. I think they were pre-recorded voice messages, if I'm not mistaken. And they were merely telling consumers that their reward certificates were about to expire. And there may have been some language in there about, when they were going to expire and, go to some kind of Best Buy store. Now, Best Buy had argued, no, these are not telemarketing calls. And the Ninth Circuit disagreed. The Ninth Circuit said, no, they're dual purpose at the very least. because you're not just telling consumers that their reward certificates are about to expire. What you're really saying is, we want you to come into the store, we want you to shop, we want you to spend your money at Best Buy. And the Ninth Circuit deemed that to be both an informational and a telemarketing purpose, and those calls were covered by the TCPA.
That's a great point, Christine. This is one of the problems that plagues, let's say, 90% of my client. It is, what is telemarketing? I'm not doing telemarketing. It's easier to defer to the fact that, again, if it's not just purely informational, imparting information, most courts will interpret these words broadly, because many courts have looked at these words and said, look, the purpose of the statute, it's a TCPA statute, it's called a remedial statute. It's there to protect consumers, so we have to read it broadly, and we're going to. And with telemarketing and advertising, they're going to be worded broadly. And if there's a question and it's a 50-50 balance, it's going to be usually resolved in the balance in favor of the consumer. We hate to say that, but that's the way it's going to be. My clients are starting to understand that, but I understand this is an entire acculturation, because it is such a mind shift. And this horrible Ninth Circuit from Best Buy doesn't help, because many courts throughout the country are following it now with regard to interpretation of what is telemarketing.
That's right. It really, you have to assume that your calls, if they at all can be an advertisement or telemarketing, or they're just not purely informational, you have to operate under the assumption that you're probably doing telemarketing. And you must make sure that you're in compliance with the TCPA as much as you can. And, you know, to kind of wrap up this discussion of the new rules, you know, there's a bunch of questions on slide 23. And I don't think we have time, unfortunately, to go through all of these dicey issues. And to be honest, there's not even clear resolution or answers to all of these questions. But David, you know, maybe we can chat for a second with the folks today about some of these issues, because everyone has had these questions, and I know you, and I know I can speak for myself, that I have gotten all of these questions many times from clients wanting to know, how do I comply with the new TCPA prior express written consent requirements? I'm not sure I'm doing it right. And these are some of the issues I think we've both seen in the space. Maybe we should at least talk about the legacy list. Maybe that could be a good topic to wrap up on this section.
Yep. So, look, there's a big fight right now, and it's a good fight. And it's before the FCC right now. And the question is, look, what about all these existing customers? I've gotten consent already from millions of customers. How in the world do I go back now and try to get prior express written consent to comply with the October 16, 2013 rules? That's impossible. And for many clients, it is a very difficult issue. Look, it's as one of my clients has decided to do, and they made a very good decision, we decided that, look, if we don't have that consent and we don't have something in writing, we're not going to call them via auto-dialed equipment. We're not going to leave text messages. There are some people that are going to be left out in the fray, because it is too difficult to determine which persons you do have consent for and which you don't. Right now, before the FCC is pending an FCC petition that literally says, FCC, look, this is insane, your new statute. You've got to deem that all of the consent that was obtained orally or written previously, written consent, prior to October 16th is going to grandfather in, even though that written consent that we got before October 16th maybe didn't have all of the 6 requirements that we need under the new rule, but because we have consent in writing, because we have it documented, please deem that all that consent transfers over and grandfathers into the new post-October 16th rules, and that we're okay. That is pending before the FCC right now because of this very issue. Some courts have actually stayed litigation on TCPA telemarketing cases because of this. And of course, you're all familiar with the Lambert Boothna Bodahagie case. And but there's a case out of California, and it said, look, this issue about whether prior written consent is grandfathered as a subject of an FCC petition, and it is a critical issue, and it actually makes a lot of sense, so we're going to stay this entire litigation. When the FCC may rule on that issue, not sure about that. So it's a very tough issue, and it's a very tough issue how to get all these legacy customers over to the new law, assuming that the new law is going to be required for even those who had prior written express consent previously.
All right. Well, I know there's a lot of other questions here, and we can take some of these questions at the end or maybe offline later. But certainly there are a lot of open questions about how these new requirements apply to existing or legacy customer lists. I do know that the DMA who filed the petition with the FCC is still talking to the FCC about this, and it's now over a year later. So hopefully we'll get some type of resolution on that. And maybe, just maybe, you can recover some other lists that maybe you might have thrown to the side because you were too afraid to continue calling based on the new requirements. Crossing my fingers here.
Christine and I are fighting the fight every day. We're before the FCC on these issues. I've personally gone and met with them. Christine has met with them, and we're arguing to the FCC. You just have to make reasonable rules. That this new telemarketing consent for telemarketers is going to literally put companies out of business, and that's not what you intend to do, because that hurts the economy. It actually hurts consumers, and it hurts businesses. And the FCC says, look, businesses, we are here for you. We are not anti-business, and we're going to show you that with regard to our upcoming rulings. All I can say is we are waiting patiently. But the pressure is on, and the pressure is tremendous. And please know that we're fighting the fight every day. Others are fighting the fight every day and doing everything that we can to get relief as quickly as possible for you companies, because we know what you're going through. We feel for you.
Absolutely. Couldn't have been said better. Well, before we get into what I call special issues, which sort of these naggy, tricky issues, we thought we would at least just go over very briefly some other TCPA requirements that apply to mobile marketing. These are ones that you probably should be doing anyway, but just a really brief recap.
So let's talk about the interactive opt-out mechanisms. You all know about this, or I hope you do, because this has been at least effective since January 14th. Yes, the new written consent rules came in effect or were effective as of October 16th, 2013, but the FCC gave everybody warning. Look, back in 2012, they said, look, we're going to change all these rules. We're going to change the interactive opt-out mechanism rules, and those rules are going to be effective January 14th. And I know many companies tried their best, but a lot of companies lagged. So real quick, with the interactive opt-out mechanisms, you've got an artificial or pre-recorded message, and if that message could be answered by a consumer, then you've got to have an interactive opt-out message. Oh, forgive me, I lost my screen. You've got to have a interactive opt-out message that at least that the person has the right to use, and they could press a button during the entire time of the call, and that it was available at the outset of a call, but available throughout the call, that they could press it and that opt out. And if that person opts out, and you get that notification, that number has to be automatically added to the company's do not call list. And I know that many of you have already have a system in place. This is an automatic process. It's almost a no thought, and it works, and you all have tested it. Testing is the key, because one of my clients, we put it together, they tested it, and then unfortunately they didn't retest it, and then it failed. So this retesting to make sure that it's working, and testing every so often to make sure you don't have a glitch in your system is very critical. Again, if the call could be answered by a voicemail or an answering machine, that message has to include the toll-free number that's going to allow customers to actually call, get a person, and opt out. Very, very critical. Abandoned calls, you all know the rule. This is back since November 15, 2012. You've got to have an abandoned call list, and you've got to document it. You've got to document the number of dropped or abandoned calls, and it's got to be, again, no more than 3% of your calls per campaign. It's got to be measured over that 30-day period. Used to be longer, but now it's a 30-day period, and you have to have that and ready to go in case you ever have to produce it. And also with the abandoned calls, make sure that you have a way and ability to examine that, document it, and store all of this information so that you're able to produce it. Don't purge. Keep the information. I understand that, you know, sometimes it's overwhelming. You've got too much information. You can't handle it, then data warehouse it. But don't purge so you have it for at least a substantial period of time. Some clients are keeping it forever. Others are keeping this information for at least 10 years just because they want to overprotect themselves.
I have a question that's come up, David, before we go to the next slide. This comes up with a lot of our clients and people who've done webinars before on the abandoned call issues. How does that present itself? Does that come in along with call complaints, TCPA complaints, where they just kind of file it in, or is that a leader in some of these cases where they're claiming, oh, you abandoned so many calls?
I've not seen one case in that regard. I've seen the type of litigation that I'm defending on a regular basis, and I think Christine is too, is litigation dealing with the failure to have a proper consent under the new rules. I'm not getting any litigation or seeing anything, or even seeing claims regarding the lack of the interactive opt-out mechanism, or the lack of the abandoned call compliance. So I'm not getting that. I think the plaintiffs stay away from it. It's not interesting. It's not relevant to them, and they're just not looking at it. However, it's important. And believe me, what happens is, and Christine will tell you this too, that once these plaintiffs lose certain type of litigation in one part of a statute, they start looking at all other parts to see, what can I pick up to make a viable case, individual or class action? So that's where they go. So that's why compliance on everything is critical, whether or not it's in vogue right now, because what's not in vogue now becomes in vogue 6 months later.
You know, I have not really seen very much on abandoned call issues either. I tend to think that those tend to be more FCC-oriented rather than plaintiff class action-oriented. I did see recently a letter in which a claimant made numerous TCPA allegations and threw in the abandoned call rate because he alleged that there were dropped calls. But they really have no way of knowing whether or not you're in compliance with that part of the regulations, as that information is not available to them at all. They can only say if they think they had a dropped call. So it really has not become a very fruitful area of litigation, but I agree that it is something you still need to comply with, because if the FCC comes knocking, we all know that those penalties are much higher than $500 per call, or even $1,500.
They're ridiculously draconian at that point, and exceed $16,000, and then there's punitive penalties on top of that. They're very, very harsh.
Absolutely. Well, I know we have about a half hour left to the presentation today. We did want to go over some do not call real quick before we get to special issues. I think it's pretty safe to say, based on this graphic, that nothing angers consumers more than being on the do not call list and being called. Really tends to anger consumers if they are registered and they still get calls to their phone, whether it's their landline or their mobile phone. I see a lot of complaints in this area, as consumers really don't want to be called if they're registered. And in terms of where your high risk is, well, these are the types of consumers that are likely to go and take some kind of action, whether it is filing a complaint with the FCC or some other regulatory agency, or actually filing a lawsuit against the company. And I've seen class action lawsuits that I've defended about do not call violations. This is something that really tends to incite consumers. And David, I'm going to give you bonus points. And anyone else who's listening, if you can name the movie that this graphic is from.
Let's see, I don't know who you are, but I will find you and I will kill you. Abandoned, I know it. I know it. It's about a lady. She was taken, or she was caught or captured or something like that. And I apologize.
You're
I
close.
can't remember. I'm close?
You're
Stolen,
close.
taken, abandoned,
Brian, did you get it?
Yeah, well, I got it from somebody in the audience. Keith Baker came in with the right answer as taken.
Yes.
Fantastic. Congratulations, Keith.
Keith, congratulations. I'm sure we'll send you something. It might be, you get the PowerPoint as a gift for your
You'll be the first one to get the PowerPoint.
The first one to get the PowerPoint today. It's a great movie,
That's
by the
right.
way. I really like that.
That's right.
Movie.
So
just a few things here. The do not call rules, they only apply to telemarketing calls, or what's called telephone solicitations.
right.
One of the things I wanted to raise, because this is an issue I keep seeing, what about for you B2B folks? You're making business-to-business calls, and most of you say, well, I don't need to scrub the do not call list because, I'm just doing B2B. Well, business numbers are not supposed to be registered on the do not call list. They're not supposed to be. They're really just supposed to be mobile or landlines. But what's been happening lately is that there are people that are using their mobile phones both for their personal use and for business use. And they are registering their numbers on the do not call list. And then you're doing your B2B campaign, and then, oh, lo and behold, you call someone on their mobile phone, and they say, I'm on the do not call list. Why are you calling me? I actually have a case on this very kind of situation where someone had a business line used, and it was a mobile phone, and they were on the do not call list. All I can say here is I know that business lines are not supposed to be registered, but I would be remiss to tell you that you shouldn't be checking do not call in any case. I have had conversations with the FTC, not FCC, about this very issue because the FTC is the one that administers the National Do Not Call Registry. And what I've basically been told is, listen, if a number is registered on the Do Not Call, it could be enforced because it's still on the Do Not Call list.
That's right.
We kind of went through, but what if it's a business number? It's not supposed to be registered. You even say on your own website, FTC, that business numbers are not supposed to be registered. And the answer I got was, if the number's on the do not call list, it could be a potential exposure for a company. So I'm going to tell you all this right now. If you're doing B2B calls, consumer calls, please make sure that you're looking at the do not call list. It is really better here to be safe than to be sorry. I mean, maybe you're not making that many calls, but I think a lot of you would be very surprised to learn how many calls you may be making that are really someone's personal cell phone and that may be registered. And at the very least, I would encourage you to at least do a test sample, have them sent over to Ryan to take a little test to see how many people are you calling that may have a mobile phone and may be on the do not call list. It is worth looking into.
Well, and the FTCs also provide a registration type, an exempt type, if you're looking at it as far as the SAN number. So you can register, if you're a business-to-business company, and you look at that and you go, well, I don't want to pay to get a SAN number to scrub. I don't feel that that's necessary. Well, the FTC's answer basically is but they don't charge for that. They have an exempt form for B2B, but they don't charge. And so we have clients that do that in order to minimize the risk for the B2B angle, but also for the mobile component, because you're kind of in a losing position. I heard that same conversation, and the FTC says basically, yeah, you got to honor it. You put that number out there, you don't, even though you put it out, basically, even though you put the number out there for your business purpose, but it's a cell phone or it's a landline, but it's not a business landline. You just went and got a landline and you didn't want to pay the business landline fee because it usually will cost more, then you don't, even though you do that, you don't lose your consumer right to opt out. So I was surprised to hear that. I mean, we've always kind of told people you got to be careful, even B2B, especially TCPA. But to hear the FTC come around and say that, specifically when it comes to do not call, is kind of strange. And that's what actually constitutes a good chunk of numbers on the national DNC list. I mean, there's I pulled the count this morning. There's 218,689,883 people on the federal DNC list as of this morning. But out of that, I mean, you got a lot of mobile phones on there, and you got a huge amount of business phone numbers. So when you go scrub B2B data for DNC, you actually lose a decent chunk. You can lose 40, 50% of your list that's on DNC. So is pretty eye-opening.
So Ryan, you know, and we're going to move faster through these slides because we want to get through this presentation with all of you because we have so much to impart, and we're going to be moving faster. But just briefly on slide 27, you've got the national registry, right? The national do not call list. You've got the state. You've got the company specific. You've got all these rules. You've got all these potential DNC issues. You've got time of day. You've got state telemarketing restrictions. It's sort of like it's overwhelming for companies. It's overwhelming for my clients. Ryan, how do you manage this?
Well, it used to be years ago. It wasn't so complicated. You had a few state lists, you know, back in the day, as they say, and it was very simple to control your own destiny and, you know, kind of manage things in-house. Now you've got 12 state DNC lists, federal lists, 218 million numbers. You've got a wireless carrier database. You got to scrub for Newstar. You've got to do it very frequently. You've got to provide the documentary evidence that you did do the scrubbing and you did it on a required basis in order to obtain safe harbor. So, you know, we've seen a definitely uptick in our business just from people needing to have a solution and a place to get the data versus, you know, trying to do it a la carte, having it in-house. So it is a complicated issue, and this is just one slice of the things you need to remain in compliance outside of tracking your consent and your dialer rules and your abandoned calls. So it is something where, I mean, it kind of makes sense to have a partner, a provider. We've been pretty fortunate because we've never had a client go ahead and turn over as far as being found defined for DNC, TCPA, so it helps a lot, I think, when, you know, we work with clients that have had issues and then had to go present their case to say, hey, we have a partner in this, we have a vendor we use. It just sounds a lot better than, oh, we took care of this in-house and here's all our information. So I think it definitely helps when you're fighting some of these cases where you may be in the right. You may have been a business-to-business call and you really were exempt, but unless you did some scrubbing and you can prove it and also defend yourself against a lot of the false accusations, I think that's also important.
I agree. Ryan, that was great. We're going to move forward now because we must, and we know that you want us to get through these slides. Next.
Well, I'll do this first one because this is sort of a girl's slide, I think. So I'm going to take this one and bounce it back to you on the next one. But we can go through this one pretty quickly. So diamonds are forever, but is consent? Well, if your answer was no, you would be correct. I mean, there are some cases that say, you know, you can't revoke consent once you've given it, but I have to tell you, those cases are really in the minority. And as of, you know, last year, we had the Third Circuit come out, say very clearly, and this is the first federal appellate court to look at the issue, basically says consumers have the right to revoke their consent at any time. And, you know, the ambiguity in the statute on this is resolved in favor of the consumer. So what the message here is, if a consumer revokes consent, listen to them. Take them off your lists. Make sure they are not able to technically dial that number anymore. Put them on your list because you don't want to keep calling a phone number that has told you, please stop calling me. And I know David can speak to this as well. I see a lot of cases, and some of the more problematic cases for me are cases I get where a consumer says, yeah, okay, yeah, I gave you consent. But, you know, 12 calls ago, I told you to stop calling me. Yet you continue to call me. Those cases are very difficult. They are bad facts. The judges don't like those facts. They don't like to hear that a consumer revokes consent, but somehow you continue to call them dozens of times. So remember, you really got to honor the consent request.
That's a great point. Ryan, let's move forward. That's right. You know what? I call it the angry bird syndrome, and that's how 90% of these cases arise. You've got someone that said, please put me on the list or don't ever call me again, and you do. They become the angry bird, and what that is a march to their attorney's office. Christine was just talking about the Jaeger case. Third Circuit said it can be revoked and consent can be revoked. It can be revoked in writing. It can be orally. Remember, there are also some other cases that help us here because it depends on your terms and conditions. Some courts say that you can freely revoke in writing or orally unless there are provisions to the contrary. And that is where you have your terms and conditions. So if your terms and conditions say, look, this matter can only be revoked in writing with our approval or words to that effect or similar words, then you have a leg to stand on that the plaintiff did not revoke properly when they orally revoked, because sometimes they're lying to you that you are not getting that oral revocation. They're just making it up. But if you have terms and conditions that say, look, you can only revoke in writing, then the plaintiff didn't revoke the way they should have, and they don't have a proper revocation. And that little issue can literally prevent a class action. However, as Christine is going to say, and I'm going to say, someone orally revokes to you, I don't care that you may have a provision that says, sorry, you got to do it in writing or it's no good. Don't stand on it. It's not worth it. It's just going to evoke a class action, a TCPA class action. It's not worth it. Just honor someone's oral request, even if you do have those, quote, provisions to the contrary. Next.
Reassigned mobile numbers. Well, this is a situation where what if you had consent from someone on a mobile phone number, but then that person changes their phone number, and guess what? They don't ever tell you. So you think you have consent to call, and you just keep calling this person. What kind of issue does that raise under the TCPA? Well, this is one of these issues that is continuing to be very controversial, including this decision from the Seventh Circuit of what does it mean to be a called party. The trend of the cases is generally tending to say that it's the current subscriber. So if you don't have the consent from the actual current subscriber, you have a TCPA issue. There are tons of arguments being made, and some of them have been successful, that it's really called party means who is the intended recipient. So that if you had consent from a phone number before and you didn't know that they changed phone numbers, you were reaching the intended recipient, and then it's not a violation. But I've seen cases on this both ways. I'm sorry to report that we have another decision that just came out this week. It's a Twitter decision that came out, of course, here in California, I believe the Northern District of California, and went the way of the Seventh Circuit, saying call party means current subscriber. It does not mean intended recipient.
And Christine, is that the way most courts are going throughout the entire country?
I think that's the trend of where things are going, until we maybe get some clarification from the FCC. I mean, I have seen cases where the courts, have said it is the intended recipient, and that is okay. But the trend from where I'm sitting seems to be going in this direction of saying not good enough. You need to have the consent from the current subscriber. So
That's
a lot
right.
of you listening are probably saying, well, how the heck do I figure that out? What if I don't know? I mean, there's not a readable database that you can look and know in real time necessarily that someone changed their phone number. And that is why there are tons of petitions pending before the FCC on this very issue, and they're under an intense amount of pressure to make a ruling in this space, but still nothing quite yet.
Next to the problem is there's no 100% guaranteed way to do what they call a TCPA right party verification. None of the vendors that are selling that as a service that I've seen will give you the guarantee that that is actually where the number actually definitely belongs to the person that's in your database. So you go pay for a service to go match your data up, but you can't. They're not giving you a guarantee that is accurate, because there is, like you said, there's no national database. So you're basically you're taking a almost not a guess, but if it's not 100%, then essentially you have error in it, and you have implications both ways, whether you make the call or you don't make the call.
Got it.
Dialogue.
Next, Ryan.
I think we could probably skip forward to a friend.
Yep.
And maybe we should just get right to vicarious liability in short,
Yep.
because I know we only have about 15 minutes.
Yep, Christine, you're
I'll
making
I'll
sense
take the
here.
gift card.
That's right.
David, I did send you a gift card, as you can see.
Well,
Super
thank you very much. And you didn't have consent, so now I'm going to sue you, Christine. Even though you did something nice for me.
I didn't send it. It's Super Duper that sent it. I just told them that you gave consent. I hope that's okay.
Great. Well, it wasn't okay, and now I'm going to sue you for TCPA. I'm going to sue them for TCPA violation here. Very quickly, because we got to move forward. Vicarious liability. I'll tell you, this is basically vicarious liability is where one is held liable for the acts of another. And vicarious liability, that concept has been interpreted as of late very broadly. Let's just go back to where this all is stemming from, the Dish Network petition in May 9th, 2013. What they said is, look, there's not automatic liability, but there's not automatic vicarious liability under the TCPA. We're going to tell you that right now. Everybody goes, great, 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 let's celebrate. Well, wait a second. What they did say is your vicarious liability is going to depend upon the interpretation of what federal common law says about vicarious liability and state common law. So you've got state principles of vicarious liability and federal common law principles of vicarious liability that will determine whether you in this particular situation are going to have direct liability for the acts of another. So let's move forward, Brian. So we're going to talk about a couple of cases and how they applied it. Let's talk about the Taco Bell case. This is where Taco Bell, really a group of subsidiary of the main Taco Bell, basically hired an advertising agency to send out a whole bunch of text blasts, and they did. They were text blasts without consent. So the plaintiff sued Taco Bell corporate, Taco Bell, the local Taco Bells, and then the text message blaster. And the court said, under a vicarious liability theory, you, main Taco Bell, and looking at federal common law and state common law, you didn't have that key word. You didn't exercise, quote, control over this potential marketing campaign. And since you didn't, we're going to hold that you are not vicariously liable for the Chicago owner Taco Bell people or from the one that did it. So it's all about, with some courts and the way they're interpreting it, control. And this is from the Ninth Circuit. This is just in July. But let's go even further. Next. We go now to this, oh, well, we lost another case, but that's okay. We're going to talk about the Ninth Circuit Gomez case. Ninth Circuit Gomez case came out, I believe, in around September of 2014 of this year after Taco Bell, and they looked at the whole issue of vicarious liability different. This is where the Navy retained a marketer to send out message blasts that were only informational. They were not text message blasts that were telemarketing. And so the Gomez case said, I don't think it matters if you're just doing an information call or otherwise. If you are an entity that retained another to send out text message blasts, you didn't have consent, and you had the right to control that sender of those text messages, you can be potentially liable for their conduct. It's sort of an expansion of the vicarious liability doctrine. Anyone in the chain can be potentially liable, and your liability is not going to be based on whether it's telemarketing, it's informational, it's debt collection, etc. So the Gomez case, Gomez out of Ninth Circuit, difficult case, and now expanding vicarious liability, and I'm telling you what we're seeing. If you retain a third party to conduct your text message campaign, and they didn't have consent when they made that campaign, there is a very strong likelihood that that potential liability of what that text messenger does is going to come back to you.
Absolutely. So definitely an area to be careful of and to make sure that you know who is doing mobile campaigns on your behalf. Are they doing them consistently with your policies and procedures? And yes, you now have to make sure you have some obligation to make sure that these companies are in compliance if they are doing advertising work on your behalf. So definitely be careful of this.
Got it. And Ryan, we can move on to the next slide because we've already talked to B2B and business-to-business calls. Let's talk about some best practices here. Next. So, number one, look at your vendor agreements, look at your supplier terms and conditions, look at your brokered list, your TCPA disclosures, your scrubbing and opt-outs, all of this, your record keeping. you've got to look at all of these things when you're doing campaigns, when you're hiring third parties. You want to look at the type of control you have. In a recent decision, in a discovery case, listen to this. The company said, well, lead company, we're going to deem that with respect to all of your vendors because you had the right to examine their TCPA practices, their compliance protocol, and you could come in and you could audit them. We're going to say that you, quote, had control over your vendors, and therefore, if your vendors are required to produce certain things in a particular lawsuit, you're going to be responsible and you have control and you have to make your vendors produce them. This is how crazy this is getting. But look at your vendor agreements, look at them, make sure that there is, if you are going to retain a third party to do your texting or whatever they're going to do, make sure that you have terms and conditions in there that protect you, that you have indemnity agreements. So if they don't do what they're supposed to do, they don't comply with the TCPA, and it says it in your contract that you can at least get indemnification from them if the suit or the claim comes back to you.
And let's talk really briefly about brokered lists.
Yes.
I hear this all the time. You know, for you advertising folks, and particularly for you attorneys, in-house attorneys, you know your business folks come up with this really great idea. They've got, and they do, they have a great idea for a campaign. And then you turn to them and you say, where are you going to get these phone numbers? And they say, oh, we're just going to buy a list. And if you're in-house counsel, your stomach turns. If you're outside counsel like me, you're saying, what? Okay, let's talk about this. The problem here is if you buy a list, that list essentially becomes yours. If it's a good list or a bad list, you really have to make sure that you are looking at these lists to make sure that whoever got these phone numbers had the proper opt-ins. And there are a lot of fly-by-night companies that get telephone lists and they don't have proper TCPA consent. And if you call them, you're going to have a real problem. So you're going to want to vet these vendors, vet these lists. You're obligated to ask questions. How did you get these phone numbers? Can you show me your web forms? Do you have disclosures? You really have to be super careful about buying a list.
That's like, we can't emphasize that enough. Can't emphasize it enough. Next. And I promise you, everybody, we're going to get through this. Next. And things that we didn't talk about, by the way, you're going to have the detail in the PowerPoint. So if we don't go through every detail, it's in there in the PowerPoint. Next. Okay.
And we're also available for questions.
That's right, at any time. So let's talk about our TCPA disclosures. They come in so many different forms. You got the paper, you got your email, you got your apps, your US mail, you got your text message. Next, let's give you an example of a good TCPA disclosure. This is, let's say, from a website sign up. And you're telling everybody, look, by checking the box you agree, and you've got a button below that I verify this is my number, I'm giving you consent to receive the text or the call via automated technology, and you usually want to say via automated telephone dialing systems or pre-recorded messages or text messages, because that's just a better protocol. We're just giving you a short example here, but that language and specifying that detail so no one can say, I didn't know what I was signing up for because you didn't explain to me.
Right, and it's about managing consumer expectations a lot of times. For some reason, consumers, when they hear mobile calls, they don't necessarily think text messaging. So we really advise you, if you do plan to send text messages, let them know you intend to send text messages. Because sometimes it's not clear to the consumer, and where there's a divide between what you think you're telling them and what they understand, that's where you can run into problems. And one other thing I want to point out on this disclosure is, you know, if you're going to give a disclosure, and I know a lot of you don't want to do this, but if you're going to have to do it for TCPA, you might as well get agreement on your terms and conditions and your privacy policy. And I really hope your terms and conditions have some kind of arbitration clause where there's a class action waiver, a huge tool, a great defensive tool to get rid of class action litigation.
That's true, and remember, there's arbitration clause. We talked about them earlier, and that sometimes can be the death knell of a plaintiff's claim. Even when you have one of these wrong number plaintiffs who said, I got a call, and I'm going to sue you because I got a call without prior express consent, and I had no business relationship with you. If your argument is going to be that, well, wait a second, everybody that you're trying to represent in the class are our customers. We have terms and conditions with consent provisions, and we have those arbitration clauses with class action waivers. It greatly helps, and we've seen so many cases, right, Christine, that have been eviscerated, class actions, because of that language. I can't tell my clients enough, make those consent provisions robust, make them clear, have them in your terms and conditions so no one said they're hidden, and have those class action waivers there, and your privacy policy. It just helps to defeat these cases wholesale. Next. I think we can skip that for now. Next.
Yeah, just so everyone knows, that's, I always get this question of how do we get people to sign up by text messaging? And, this is what is typically called a call to action. And you have the user initiating a text message to you first and then confirming some kind of opt-in. And this is what I call a double opt-in process. This is how you can get consent through text messaging, but it really requires your signage, as you can see, to be very robust. You need to have those disclosures in there. Moving on to scrubbing.
Yep, the sign-in and the clarity of your opt-ins is absolutely critical. Let's talk about scrubbing and opt-outs. Look, at any time anyone opts out or seeks to opt out, just honor it. Again, we told you earlier, verbal and writing. I know you may have those terms and conditions that's saying you can't opt out unless it's in writing. Don't stand on that because it's not worth it, because all that's going to do is get the angry bird to come with a suit. Also, have your policy that includes regularly scrubbing those phone numbers against the federal DNC list, and it should be often and frequent. Ryan can tell you how often and frequent that should be. And you've got to have your own internal list that you keep that has a list of persons who said, don't ever call me again. And make sure when they do that, that you have this list. It's not just a list in the vacuum that your agent is going to review or that someone's going to see, but that it's literally tied into your dialer from a mechanical and technical standpoint, so that dialing system can never pick up that number again once that person says, I want to opt out. You want to make sure they get on a list, that list is coded, and that list is tied into your dialing equipment so they never can be called again. Next.
A lot of people don't seem to realize this, but being organized and having good records is also a great defensive tool to these cases. For your consent records, you really need to be holding on to them for 4 years, because that's
at least, Christine?
Would
you say at least? Okay.
I would say at least. I would say at least. I try to say 5, if we can do 5. And I know a lot of you say, but I can't keep that kind of volume. And there are ways that you can, consolidate things, and we can talk about that separately. But you really need to have at least 4 years, because that is your statute of limitation. I had a case where a text message was sent 3 years and 9 months prior to the complaint being filed. That's how far it can go back. You really have to have good record keeping. You really need to be able, what you really want to be in a position to do is when you get one of these cases, you want to be able to say, okay, so-and-so grabbed this, this, and that. You put it into a nice package, and you present it to your attorney, who can then get rid of the case for you very quickly. And that means you need to be organized. You need to be documenting the date and substance of changes. If you're making changes to websites, you've got to be making, keeping track of who opted in when, what the website looked like. I am going through this exercise today with a client. You need to be able to make sure you knew what that consumer saw on the date and time that they signed in. And there's different ways to do this, but it's really important that you can show that kind of information when you have one of these cases.
That's so true. And one of the other keys, the keys that has helped many of my clients and myself eviscerate cases, class actions, is the recording. Companies, I think people have asked me, is it better to record or not to record? it is always better to record because that is your window to the world. I'm litigating a class action literally right now where I have fantastic notes of what occurred on 7 different calls, and they're so detailed that no one would believe you could possibly make those up. But plaintiff is fighting them. Every one of those calls was recorded. Unfortunately, at the time, the client had a lax recording protocol retention policy, and they were purged after 6 months. That didn't help us here, and that would have been the window to the world. It would have stopped this case literally in its tracks from the get-go. Make sure that you're recording, of course, that you're complying with all the laws regarding disclosures and consent with recording. Absolutely critical. Again, another window to the world, especially when you say that every single one of our calls is recording and we have documentation to back it up. You wouldn't believe what you could do with a lead plaintiff on a class action.
And make sure that if you are doing call recording, that at the very beginning of that conversation, right after, hi, I'm so-and-so from so-and-so company, this call is being monitored or recording for quality assurance purposes. You want to get that out right away. Timing can be critical there because you also don't want to be named in a different type of class action, which are these call recording class actions that I also see a lot of, and David, I know you see a lot of them too. I actually had a case where there was a difference of 30 seconds because somehow the consumer got into this conversation with the agent and didn't get out that disclosure right in the beginning. There was a pause, and they sued on a class action on that basis. So you got to get it out right away on your script.
Christine is so right, and what Christine is also saying is that with regard to your incoming calls where you have a recording protocol, you need to have that incoming warning front and center that no person can call your company without hearing that. That's the first thing they hear is your recording protocol. And guess what? That when they call in, there's no way they can bypass that recording protocol by pressing an extension, by pressing 0, or any button of any kind. They are forced to hear that recording protocol. So you can say, when you're dealing with the class action, okay, maybe somehow this one person, called and didn't get the recording warning, or we called them and didn't get it, but guess what? For the entire class, all those persons who called into our office, they absolutely got it because we have it on a locked loop. And therefore, plaintiff says, I have nowhere to go. I can't proceed with this class action. It's too difficult because you've had this protocol in place.
Well, let's just wrap this up with this last slide. This is, I think, what David and I would really consider what you need to have in terms of a compliance readiness program. You obviously need to understand the law that's applied to your actual business, what kind of calls you are making, and you want to make sure you have some kind of policies and procedures in place, including looking at those telephone scripts and making sure you have what you need in terms of disclosures. You obviously need to be training your employees because they need to understand what their obligations are and what they are doing, particularly when they are the face of the company on the telephone. You want to monitor your complaints because, honestly, complaints can be a real window into what your weaknesses are on your compliance, and that is very critical. You want to maintain great records, and you also want to test your policies to make sure that you are doing what you think you are doing, because you may be surprised that it may not be working as you think it is.
That's right. Christine and I have been, I've gotten some surprises I didn't like in a case when I knew my client had fantastic policies, but 2 of the policies they had no clue didn't work. 2 fantastic protocols were not functioning, and they weren't functioning for about a year period, and no one knew because they just assumed it had worked. They tested at the beginning, and no one saw what happened throughout time. So always do routine testing. Your IT people can do this. It's very easy. It doesn't create a great burden, but it could protect you from tremendous liability. First of all, thank you all so much on behalf of myself and Christine. We know this has been very long, and it's hard to sit through a lecture this long, and we hope we provided you with good information. Christine certainly and I are available to discuss with you. You have our information on the last 2 slides, and you can certainly call us. We are open books, and we hope you enjoyed today's session, and thank you so much for your indulgence. And we can't thank Contact Center enough for sponsoring this event and for providing all the useful information that you do and with the help that you provide to the industry. Thank you, Ryan Thurman.
Thanks, David. I appreciate you and Christine being available today and spending a decent amount of time, I think, covering a lot of the major issues. And I know we didn't have time quite for a full Q&A, but there's a few questions I think we can take offline and email people some responses. And also we'll be emailing out a link to the slides. You can get a copy of those, as well as a link to the audio and the way to stream it. So look for that next day or so, and look for some information a little bit more about contact center compliance, maybe how we can help you put together some of these compliance programs, scrubbing, and some guidance. So, down the road, 5 years from now, if you do have a compliance problem, that's kind of why such a lot of people use a solution versus trying to kind of do things themselves. So make sure that's available. We also have an event next week in Clearwater, Florida. If you haven't signed up, a few may be there with the Compliance Summit. We do still have a few seats left, so if you want to give us a call or check that out, we'll have some information available. That's on December 10th, Clearwater, Florida. We got a full day to kind of tackle these issues and go a little more in depth, because I know everybody's got particular questions they really need answered. And unfortunately, we don't have a lot of more time, nor do we have any answers on some of the bigger petitions from the FCC. So hopefully we'll be putting something out also about future events, kind of first quarter next year, so look for something on that. And again, thank you again for putting together the information here so we can break things down and give people some useful tips. I particularly like those last couple slides you guys had about kind of best practices, and then the other tip, the good tip was the slide about the consent requirements, the different types, and what needs to be in there. I think those are all kind of common threads that we can all kind of be on the same page. Then, as the industry, they can maybe kind of fight some of these challenges together.
Well, thank you very much, Ryan, and thank you, David, and thank you, Contact Center Compliance.
Bye-bye.
Please feel free to contact us with any questions.
That's right. Ryan will send you the PowerPoint. Bye-bye.
Always a pleasure. Thank you.